there are some inconveniences related to serving, but I want to let you know that your service is absolutely respected and appreciated, and most of all, it's necessary. Far more than me, you're the most important people in this room. And so to the extent that I can do anything to mitigate inconveniences with the explanation to anyone that needs it, that there's a cranky judge who's very inflexible and is making sure that you're here every day, and make sure those other folks reschedule appointments and things in ways that they might not otherwise be able to do. I'm happy to step up and try to do that. I do very much appreciate your service. Everyone does. With that, let's see. I think before I even administer your oaths to you, I do have a scheduling issue that I will need your help with, and that is, I believe that it is true that a week from today is a holiday. What are those holidays where some people get it and some people don't? And most importantly, my concern is we don't get it here at the state, but I'm not sure if your kids get it with school, if you have any, or those concerns. So it's not a high pressure tell me this very moment, but what I'm hoping is that maybe you can confer by the time the lunch is over, something of that nature, and let me know. My preference is, if at all possible, that we hold trial on Monday next week and continue. I will say from experience that I used to be much nicer and start slowly in trials, and then what I learned is all I'm really doing is creating a crisis at the end. So I try to get things rolling and hold trial when we can to avoid that, and that's the purpose behind that. But if it does create hardships for you, or really I will even say alarming or very concerning conflicts with getting children out of school, please let Ms. Deanna know, and she'll relay that to me. But I'm hoping we can have a trial next Monday. We can get back to that perhaps after lunch when you've had an opportunity to consider it. All right, with that, let me swear you all in as in panel jurors. If you'll please stand. I'll ask each of you to raise your right hands. Do you and each of you solemnly swear or affirm that you will render a true verdict according to the law and evidence submitted?
Yes.
Yes. Thank you. Please be seated and let the record reflect that there was unanimous nodding in assent. Everyone has taken that oath. Thank you. All right, with that, I now have additional instructions for you about your job, my job, and the job of the lawyers. I will have other instructions during and at the end of trial. You will also receive a written copy of all instructions. Your job is to find and determine the facts in this case, which you must do solely upon the evidence received in court. There are important rules governing your conduct during the trial. First, you may discuss the evidence during the trial, but only among yourselves and only in the jury room when all of you are present. During the recesses and adjournments, while the trial is in progress, do not discuss the case with anyone other than yourselves as a group. The kinds of things you may discuss include the witnesses, their testimony, and exhibits. Be careful, however, not to make up your minds or try to convince others about the final outcome of the case until you have heard everything. All the evidence, the final instructions of law, and the attorney's closing arguments. It would be unfair to the parties if you attempt to decide the outcome of the case before you begin final deliberations. Second, it is for you to decide whether the witnesses know what they are talking about and whether they are being truthful. You may give the testimony of any witness or other evidence whatever weight you believe it merits. You may take into account the witness's ability and opportunity to observe, any interest, bias, or prejudice that the witness may have, and the reasonableness of the testimony considered in light of all the evidence in the case. Third, To minimize the risk of accidentally overhearing something that is not evidence in this case, please continue to wear the juror's badges while in and around the courthouse. If someone happens to discuss the case in your presence, report that fact at once to a member of the court staff. Ms. Dean is usually the most available to do that, so thank you. Fourth, though it is natural to visit with people you meet, please do not talk with any of the attorneys, parties, witnesses, or spectators, either in or out of the courtroom. If you meet in the hallway or elevators, there's nothing wrong with saying good morning or good afternoon, but your conversation should end there. If the attorneys, parties, and witnesses do not greet you outside of court or avoid riding in the same elevator with you, they are not being rude. They are just carefully observing this rule. Fifth, do not consider anything you may have read or heard about the case outside the courtroom. During the trial and your deliberations, avoid news accounts of the trial, whether on radio, television, in the newspaper, on the internet, or elsewhere. If you happen to see or hear any news account of the trial, please report that fact to a member of the court staff. Sixth, do not attempt any research, tests, or experiments, visits to any locations involved in this case, or other investigation. It would be difficult or impossible to duplicate conditions shown by the evidence, and therefore your results would not be reliable. That conduct also runs contrary to the rule that your verdict must be based solely upon the evidence presented to you. Nonetheless, in your deliberations, you need not ignore your backgrounds, including professional, vocational, and educational experience. Seventh, because you are only to consider the evidence presented during the trial of this case, you may not refer to print or electronic resources before rendering your verdict. This means that you may not use your computer, telephone, smartphone, or any other electronic device to email, text, comment on, or research any issue that may arise during these proceedings. You may not use any internet resources, including internet dictionaries, Google, Safari, Yahoo, Wikipedia, or any other search engine to research any issue, the parties, witnesses, or attorneys. This prohibition includes the use of artificial intelligence, AI, such as ChatGPT, blogs, and social networking sites, such as Facebook, Instagram, LinkedIn, X, which is formerly Twitter, YouTube, Snapchat, and any of the others. Again, you may rely only on the evidence presented in the trial in this case. Last, there are at least two sides to every lawsuit. It is important that you keep an open mind and not decide any part of the case until the entire case has been completed and submitted to you. Your special responsibility as jurors demands that throughout this trial, you exercise your judgment impartially and without regard to any sympathy, prejudice, or any actual or implicit bias of which you are or may become aware. These restrictions apply at all times during the trial, recesses, deliberations, and when you are away from the courthouse, 24 hours a day, 7 days a week, until you return a verdict in open court and are discharged by me. As jurors, you are charged with considering the evidence impartially and without bias. Throughout the trial, you and your fellow jurors must strive to be impartial and unbiased in considering the evidence and in reaching a verdict. This is not an easy task because as humans, we all have biases. Biases may be based on assumptions or feelings we have about people of a particular type, class, or background. They can affect what we think about other people, how we view information we receive from them, how we remember that information, and how we develop opinions and make decisions. We may not always be aware that these biases exist, which is why we call them implicit or unconscious biases. For this reason, as you participate in this trial, I encourage you to consider these guidelines. 1. Avoid forming a fixed view of a party, a witness, or the evidence based on your initial impressions without carefully examining the basis for that view. 2. Ask yourself whether you would have a different view of a party or would find a witness to be more or less believable if they had certain characteristics. For example, if they were richer or poorer, more or less educated, did not have a particular disability, or were of a different race, nationality, gender identity, sexual orientation, or religion. 3. Take the time you need to reflect carefully and consciously about the evidence and keep those considerations in mind. 4. Focus on individual facts. Do not jump to conclusions that may be influenced by unintended stereotypes or associations. Next, you are allowed, but not required, to take notes during the trial. Note paper will be provided for this purpose. Notes should not take the place of your independent memory of the evidence. When taking notes, please remember the importance of paying close attention to the trial. Listening to and watching witnesses during their testimony will help you assess their appearance, behavior, memory, and whatever else bears on their believability. At each recess, you may leave your notes on your chair or take them with you to the jury room. At the end of the day, the bailiff will store your notes and return them to you when the trial resumes. At no time will anyone read your notes. At the end of the case, the notes will be collected and destroyed. Next, ordinarily, the attorneys will develop all pertinent evidence. It is the exception rather than the rule that an individual juror will have a question that remains unanswered after all of the evidence is presented. However, if you feel an important question has not been asked or answered, write it down on a piece of your note paper and give it to the bailiff before the witness leaves the stand. I will decide whether or when your question will be asked. Rules of evidence or other considerations apply to questions you submit and may prevent the question from being asked. If the question is not asked, please do not give it any further consideration, and please do not hold it against either side that you did not get an answer. Excuse me. All right, next. It is my job to preside over the trial, decide and instruct on questions of law, and rule upon what evidence may be admitted for your consideration. No gesture, remark, or comment I make should influence your decision in this case. At times, I may ask questions of witnesses. If I do, such questions do not in any way indicate my opinion about the facts or indicate the weight I feel you should give to the testimony of the witness. Next, the defendant in this case is a corporation. The plaintiff in this case is the state. Both are entitled to the same fair and unprejudiced treatment as an individual, and you should decide the case with the same impartiality as you would use in deciding a case between individuals. Next, in deliberating on this case, it is your duty to consult with one another and to decide the case only after an impartial consideration of the evidence. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is wrong. But do not give up your honest conviction as to the weight or effect of evidence solely because of the opinion of your fellow jurors, or for the mere purpose of returning a verdict. Remember that you are not partisans, but judges of the facts. Your sole interest is to determine the truth from the evidence in the case. Next. The rule of exclusion of witnesses is in effect. This means that until excused as a witness by me, all witnesses will remain outside the courtroom except when testifying. They will wait in the areas directed by the bailiff unless other arrangements have been made with the attorney who has called them. The rule also forbids witnesses from telling anyone but the lawyers what they will testify about or what they have testified to. If witnesses do talk to the lawyers about their testimony, other witnesses and jurors should avoid being present or overhearing. The lawyers are directed to inform all witnesses of these rules and to remind them of their obligations. The parties and their lawyers should keep a careful lookout to prevent any potential witnesses from remaining in the courtroom if they enter by mistake. Next, during recess, do not discuss this case with anyone other than yourselves, and then only in the jury room when all of you are present. Do not attempt to decide the outcome of the case before you begin final deliberations. Please continue to wear the juror's badges while in and around the courthouse. If someone other than a fellow juror happens to discuss the case in your presence, report that fact at once to a member of the staff. If you happen to see or hear any news accounts of the trial, please report that fact to a member of the staff. Next, when an exhibit is presented to you in open court, you should not discuss it with other jurors. You should not point out to another juror what matters that seem important to you. You should not whisper back and forth with other jurors about the exhibit. You will have an opportunity to discuss the exhibits in the jury room. And I'll take this opportunity to also let you know some of the evidence and exhibits that you'll see in this trial have redactions, so portions of language or images that are blocked off, so they're not visible, just so that you all know that's a result of court decisions and not the result of any decision by any counsel, so that you understand why those are blocked off that way. All right, next. A deposition is testimony taken under oath before trial and has been preserved in writing or by video. This testimony is entitled to the same consideration as any other testimony at this trial. Next, interrogatories are written questions asked by one party to another before trial and answered under oath. The questions and answers may be read at trial as evidence. The answers read to you are entitled to the same consideration as any other testimony. Next, a request for admission is a written statement of fact, opinion of fact, or the application of law to fact asked by one party to another party using pretrial requests. You are to consider any such statement as conclusively established for the purposes of this trial. Next, the rules of evidence do not ordinarily permit a witness to testify as to an opinion or conclusion. However, a witness who is qualified as an expert in a subject may be permitted to state an opinion as to that subject. After considering the reasons stated for an opinion, you should give it such weight as you believe it deserves. You may reject an opinion entirely if you conclude it is unsound. Next, an expert witness is permitted to state an opinion based upon a question which, for the purposes of trial, assumes as true certain facts which may or may not be true. It is for you in your deliberations, however, to determine from all the evidence whether or not the facts assumed have been proven to be true. Next, it is the job of a lawyer to object to questions, testimony, or exhibits the lawyers believe may not be proper. I will sustain objections if the question or evidence sought is improper for you to consider. When I sustain an objection, the question or evidence is not allowed. You must not consider such evidence nor may you consider any evidence I've told you to disregard. By itself, a question is not evidence. You must not speculate about what would be the answer to a question that I ruled cannot be answered. If I overrule an objection, then the question or evidence will be allowed. And finally, a trial begins with the lawyers telling you what they expect the evidence to show. These statements and other statements made by the lawyers during the course of the trial can be of considerable assistance to you in understanding the evidence as it is presented at trial. Statements of the lawyers, however, are not themselves evidence. The evidence will be the testimony of the witnesses, the exhibits, and any facts agreed to by the parties. After you've heard all the evidence, I will give you final instructions on the law. The lawyers will argue the case, and then you will retire to the jury room to arrive at a verdict. The plaintiff's attorney may now make an opening statement. When you're ready.
We approach briefly for a very small item.
Yes, and ladies and gentlemen, just so you know, I'm going to hit a white noise button. I think I may have done that during your jury questioning, and that's just so we don't have to have you leave and come back in. So it's rude, but it is for a very helpful and necessary. All right. Thank you for putting up with the white noise, ladies and gentlemen. And with that, counsel, whenever you're ready.
Thank you so much, Your Honor. Thank you, ladies and gentlemen. It's great to see you again. If there's any technical issue with the audio or screens, please let the sheriff know. I just want to make sure that you can hear me from here, and that it's less important to see me, but I want to make sure you can see the screens, okay? Good morning. My name is Don Migliori, and as I mentioned to you last week, I'm here on behalf of the state of New Mexico. In the courtroom today is New Mexico Attorney General Raul Torres. The Attorney General has brought this case against Meta on behalf of the people of New Mexico under the Unfair Practices Act. The evidence in this case will be that Meta has knowingly made false and misleading statements, particularly about the safety of its platforms for teens and preteens who are on their platforms and at a significant risk of mental health harms and sexual exploitation. As you can see, we have a large team here working on the case. I want to introduce to you some of the team members you'll be hearing from during the course of this trial. Steve Perfreeman and Lauren Perry from the Department of Justice of the Office of the Attorney General, as well as Linda Singer and David Ackerman. In the back, you'll see at the first row in the brown top, Gina Veldman. Gina Veldman is a technician. She's the one that'll be helping navigate all of this information on the screens for you, and from time to time you'll hear me call out her name. Depending on the flow of witnesses at trial, other lawyers may be appearing here before you. And I say that because this has been a very significant undertaking, as you know, and it's required a lot of hands. And beyond that, those I've introduced, you may see lawyers and staff coming in and out. And I don't want that to be a distraction. In fact, I want you to understand that we take your time very, very seriously. And so if there is activity on our side like that, it's because we value the time that you've made for us, and it's so greatly appreciated. As I said to you all last week, I want to thank you for your service, asking you to take time to listen to this evidence. over the next several weeks is a lot to ask. It's time away from your families, time away from your friends, time away from your jobs. We take that sacrifice very, very seriously. We feel strongly that your involvement in this process is important because cases like this in our country are decided by juries. That's what the United States and New Mexico constitutions protect and afford, and you're playing an important role in the search for justice. So on behalf of the Attorney General, the Department of Justice, and the state of New Mexico, again, please accept our sincerest thanks and appreciation. So why are we here? The Unfair Practices Act is a remedial statute. That's the law. You'll hear about the law from the judge at the end of the case, as he said. It's designed to fix something wrong. And the state's alleged that, in this case, Meta has made false and misleading statements with respect to the safety of youth on its platforms. It'll be your job to decide if Meta's misrepresentations on youth and safety on its platforms require that you enforce this remedy. It'll be the judge's job to give you the instructions that you'll need to apply at the end of the case. And today, my job at this moment is to give you a roadmap. I'll be covering various issues today, but this general roadmap is a roadmap about the various misrepresentations that the state believes Meta made. The state intends to present to you over the next several weeks testimony from several former employees, some current employees, experts in the fields of science and technology, health sciences as well. You'll also hear testimony from regular people from the state of New Mexico. You'll hear from teachers, school principals, police officers, investigators, parents, healthcare officials. In providing you this roadmap, I'll be sharing with you examples of statements that Meta has made about the safety of its platforms. Statements that the state believes are misleading and deceptive, and in some instances, outright lies. In this roadmap today, I'll be sharing with you what we believe to be the evidence inside of Meta through their internal memoranda, their internal emails, and their internal presentations to its employees. This roadmap previews several weeks of evidence in just 2 hours. So please understand that this abbreviated presentation is not cherry picking. We're not here to pull things out of context. In fact, the purpose of this roadmap is to give you a view over the next several weeks about the context around these very serious issues that we intend to prove to you through evidence. Now, let's talk about the roadmap. The first stop on this roadmap is the concept of profits over safety. The theme throughout this trial is going to be that Meta put profits over safety. That is, that Meta, through its development, through its platforms, prioritized profits. It's true in the United States that all companies have goals to make money. There's nothing wrong with that generally. But what makes it different in the case of Meta is that we believe the evidence in this case is that Meta made its profits while publicly misrepresenting that its platforms were safe for youth, downplaying or outright lying about what it knows about the dangers of its platforms. The deceptive statements in this case at issue include statements that children on Meta's platforms are safe from bad actors, sending them explicit materials. The deceptive statements include statements like children are safe from inappropriate contact in interactions with unknown adults, that children are safe from exploitation and trafficking, that children are safe from harmful content directed at them from the platform's algorithms, that children are safe from mental health risks like excessive use, addiction, depression, anxiety, eating disorders, sleeping disorders, self-harm, and even suicide. Despite these public misrepresentations, the evidence will be that internally, Meta clearly knew that youth safety is not its corporate priority, that safety measures were under-resourced, ineffective, and deprioritized, that youth safety was less important than growth and engagement. And by the end of this trial, I believe the evidence will show that you will associate the term growth and engagement with profits, with making money. You'll even see that in this case, Meta put over safety its view about freedom of expression, meaning it was more important to Meta, the evidence will be, that people be able to freely express good, bad, or ugly what it wants on their platforms. By misrepresenting, deceiving, and outright lying about the safety of its platforms for teens and preteens, the evidence will show that Meta has acted with total disregard, making its conduct unconscionable, a term that you'll hear multiple times during this trial. By not only not adequately protecting teens and preteens from the platform's harms, but instead actually targeting tweens and teens to try to get their eyeballs on the app to further growth and engagement. I'll say that again. The evidence in this case will be that Meta prioritized growth and engagement, that is, a prioritized targeting and marketing to teens and preteens over safety, and especially of safety of youth. The evidence will be that Meta's conduct is willful, it's unconscionable, and the evidence will be that Meta broke the laws of New Mexico by violating this Unfair Practices Act. Now, it all starts with the culture of the company, and as you heard in the opening, in the voir dire process, a lot of people know who Mark Zuckerberg is. He's the founder of Facebook, and he's the head of the company Meta. Some of you may know Adam Mosseri, the CEO of Instagram. Together, they are the leaders of Meta's platforms, Zuckerberg and Mosseri. The evidence will be that the culture of this company is certainly evident in the words that you're going to hear and see from them, and that the actions of these two individuals demonstrate their prioritization of growth and engagement over safety. We anticipate that you'll hear various statements throughout the course of the trial from both. We believe that the evidence will show that most of what you hear from them in internal Meta communications centers around the prioritization of making money. Now, Meta also prioritized freedom of expression. What role does freedom of expression play in a case like this? Well, the evidence will be, and you'll understand it when you see some of the documents and letters of Zuckerberg, the evidence will be that from the top, Mark Zuckerberg put freedom of expression, freedom of users on their platforms to post what they want above safety. In fact, you'll see that from Mr. Zuckerberg, with respect to safety, he simply says it's not the main point. This is where the extreme danger lies, ladies and gentlemen. When you have a platform like this and people can post what they want, good, bad, and ugly, many people will post with good intention. But without safeguards and guardrails, many bad actors horrifically will post things that put children at risk. The evidence will be that the culture at Meta is not safety first. It's growth and engagement first. It's freedom of expression first. It's brand first. But it's not safety first. Now let me show you, using our roadmap, how this roadmap might work. In answering the question that the court will ultimately give you at the end of the day, the law that applies, you'll be looking at statements made by this company, by Meta, and comparing it against what Meta internally knew or should have known about the truth of that statement. Meaning what it is that that statement really means as opposed to what it is that is on the face of it. Does the statement itself tend to, or does it deceive? We believe the evidence in this case will be that Meta made false and misleading statements that were knowingly made, that may tend to, or do in fact deceive or mislead any person. You'll see at the end of the case that the law that you hear you'll be applying tracks many of those words. So when thinking about these statements as we go through this opening and we give you this roadmap of misrepresentations and false misleading statements, you'll be thinking about whether or not the statement that we give may, tends to, or does in fact deceive. And when we say knowingly, we mean that it's something that is actually known when looking at the internal documents and evidence of the company, but also something that should have been known had this person who made the statement bothered to do the reasonable due diligence to figure it out. That's what knowingly means in this state. We believe that Meta's practices were unconscionable, taking advantage of the lack of knowledge and ability and experience of the teen users and their parents. And that unconscionability question, we believe, will be one of those questions by the end of the case that you will answer based on the evidence as being actual, being true. So let's start with the first statement. Again, as the court said, this isn't evidence. These are examples of statements that you may hear, that we expect you to hear during the course of trial. The first statement on this roadmap is from Mr. Zuckerberg himself, CEO and president of Meta, on October 6, 2021, posted on Facebook. At the heart of these accusations is the idea that we prioritize profit over safety and well-being. That's just not true. It's very important to me that everything we build is safe and good for kids. That is an example of what we believe in this case will be the type of statements that are false and misleading. So how do we look at it? Let's look at what's been said inside the company. Now, there are people that you're going to hear from throughout this trial who are brave enough to speak out. You'll hear from brave people employed formally by Meta who risk their jobs at times or reputations, or both, to shine a light on corporate misconduct and reveal what Meta was doing willfully. One of these people is a former senior user experience, when you see UX, user experience researcher, and her name was Dr. Natalie Troxel. And we believe this is the evidence that you will hear about this issue of profits over safety.
When you say the prioritization of the company, what do you mean by that?
That the company wasn't prioritizing positive child development.
In your experience, what was the company prioritizing?
Revenue.
And by revenue, do you mean making money?
Yes.
And how, in your experience, did Meta seek to prioritize revenue and making money?
It seemed like when I was there that Meta was trying to increase engagement, trying to increase how much time people spent using their apps in an effort to have more eyeballs on the apps for a longer period of time, which can get them more advertising revenue.
Those are my words. Those are the words of a former senior researcher at Meta about the priority of revenue over safety. You'll also hear from another senior scientist, researcher at Instagram. Dr. Allison Lee also had the courage to speak what she felt was the truth, and the evidence will be, in this case, that she also saw that safety was not first in the corporate culture.
During your tenure at Instagram, do you feel like the company did enough to warn users about the bad experiences they might encounter on the platform?
No, I do not think that they did a sufficient job.
During your tenure at Instagram, do you feel like you did everything in your power to try to reduce known unsafe experiences teens were having on Instagram?
I think I did the best that I could with the locus of control that I had as a researcher.
During your tenure at Instagram, do you feel that the company's leadership did the same?
I think that the leaders at Instagram, their attention and their priorities were elsewhere, namely in growing the product, growing the platform, and increasing engagement. I would say that they perhaps cared as a third or fourth order priority about safety and well-being. I don't think that they did not care at all. And I would say that those other concerns about engagement and growing the platform and product superseded those concerns about safety.
Ladies and gentlemen, the evidence will be that this senior researcher thought safety ranked third or fourth among the priorities at the company, but first was growth and engagement. First was revenue and profit. Now, we don't have to listen to just employees. The evidence in this case will be that even Mr. Zuckerberg internally, in an internal letter going back to 2018, would evidence the type of prioritization that in fact was in the culture of Meta. This subject line of this is safety first. This is an internal Meta document. Mr. Zuckerberg, writing to senior people at Meta, wrote, "I care so deeply about free expression that I would find it untenable to subordinate free expression in any way that communicating the idea of safety first suggests." He goes on to say, keeping people safe is the counterbalance and not the main point. This corporate culture of not making safety more important has permeated the company for years. Internally, you'll see, the evidence will be, you'll see presentations like this, presentations of researchers who look at the issues of safety within the company. And in 2020, this is an example of one of those types of presentations, specifically on child safety, where if you read the first line, it says Instagram, minimal child safety protections. This is 2020. So, you'll hear from a lot of courageous, brave people who at one time worked at Meta and have decided to speak about their observations of this willful and deliberate conduct within Meta from their perspectives. All three of these witnesses right now are expected to testify live at trial. In fact, Mr. Behar may be even testifying as early as this afternoon or tomorrow. Mr. Behar was a former director of engineering. He worked at Meta both at Facebook from 2009 to 2015 and then at Instagram from 2019 to 2021. He will testify about his personal history working for Meta, explaining that he was compelled to return to Meta as a consultant when he learned that his daughter was exposed to negative experiences on Instagram and found there were no ways to report these experiences. Mr. Behar will describe several internal survey studies that he conducted that revealed that his daughter's experiences were actually justified. They were not unique to her, and that these teens that he surveyed had been exposed to harmful and bad experiences on Instagram. Mr. Behar also talked about the fact that he brought these issues to the attention of the leadership, including Mr. Zuckerberg and Mr. Mosseri, and that he received no response to these concerns. He left the company, and he'll come and testify to you about the work that he did after leaving Meta for the second time to continue his quest to understand the safety hazards, the safety challenges of children on these platforms. You'll hear from Mr. Brian Boland. Mr. Brian Boland will testify this week as well. He's the former vice president of partnership product marketing at Meta. He spent 11 years there, and he was largely responsible for advertising that you see on Facebook. He'll testify that he resigned from a lucrative position at Meta around 2020 because Meta's leadership repeatedly chose to grow the company over keeping more people safe. While the company did make some investments in safety, he will testify that those investments were routinely abandoned when leadership learned it would impact the growth of the company. Mr. Boland will also testify that the value of social media is the network of people who use it. And with regard to tweens and teenagers, Mr. Boland will tell you that they are important to Meta because they are not fungible. Once they get on social media platforms, they are the most loyal customers. Finally, you'll hear from another person who worked for many years at Meta. His name is Dr. Jason Sadazan. Again, a researcher and somebody who focused on child safety across Meta's multiple platforms. He'll tell you about his experience. He'll tell you about a change in dynamic in November of 2021 when another researcher spoke out at her risk about the dangers within the platforms for children and the lack of prioritization of that at the highest levels. When that researcher testified in November of 2021, Dr. Sadazan noticed an immediate culture change within the company. And he will come here and testify, I think at the beginning of next week, about that culture change, about how at that point lawyers got involved with research, lawyers got involved with protecting the brand of Meta over protecting the children on Meta's platforms. And he will also testify that at the instruction and direction of those lawyers, he was personally asked to destroy and bury data suggesting that there was a problem. So, going back to our roadmap, let's take a quick break from the story of misrepresentations and look at what we're doing. We're talking about Meta. Meta is a host of different platforms. And so here you see all five, probably most familiar with Facebook and Instagram. WhatsApp and Messenger are messenger platforms. You'll hear a lot of testimony about that during this trial because those platforms have something called end-to-end encryption. It's a place where people from the other platforms can be brought over and have conversations that are not traceable, conversations that disappear, conversations that obviously pose risk to young users. And Oculus is a virtual world. That's where Dr. Sadazan started his research or had his research at a significant time. And that's a world where interactions between users and adults was a major concern. So how does this all work? Well, you heard a lot about algorithms. There's this machinery behind the platform that does a lot of things. It causes you to see content that somehow remarkably interests you. It causes you to get advertising that remarkably is advertising about things that you were thinking about buying. That algorithm is the machinery behind these platforms. And I'll show you a diagram for fun of what that machinery looks like. One of our experts will come here and explain this to you. I can't. But this is the machinery. This is the complexity of how your phone or your computer, when using this platform, gathers information about what you're seeing, how long you're seeing it, whether you like it, whether you forward it to somebody else and share it, how long you stay on that platform. It gathers the information about your behaviors, and it uses that information to process what else it thinks would be relevant. But that's not all it does. It causes you to stay on the platforms longer. And one of the themes of this case, the evidence will be, is that in trying to optimize growth and engagement, Meta designed these platforms to keep the eyeballs of kids, teens and preteens, on the platforms for as long as they can. How do they do that? In the middle, you see infinite feed feature. You'll actually hear from the person live who invented the idea of infinite scroll. The idea when you're on your phone and you're on a platform and you constantly throw your thumb up and it never ends. That infinite scroll feed is a design feature. When he designed it, it was to read news. What it became is something very, very different. It became a design feature used, the evidence will be, used by Meta to keep eyeballs on their platforms. Other features, design features to keep users on the platform are likes, notifications when you leave the platform and you get a notification to come back. You'll hear about all of these features, you'll hear about all these design features and their purpose by experts. Some of those experts are here. From Princeton, you'll hear from Dr. Narayanan. Dr. Narayanan is a professor of computer science at Princeton University, and he'll explain how the Meta's algorithm chose what to show teens based only on what will keep them using the app for as long as possible. He will testify that the machine learning algorithms do not consider the content of what is being shown to teens. Instead, they look for mathematical relationships between teens' behavior and what's been shown to them, and they push more and more content that keep them on the app. He'll also testify about how the content moderation technology that Meta promised would keep kids safe on its platforms are not the types of moderations that actually work for teens. He'll also testify that some of that design is deliberately ineffective. You'll also hear from Dr. Damon McCoy. He's a professor of computer science at NYU. He will talk about the other features, not the algorithm as much. And he'll talk about how those infinite scroll, autoplay, like buttons, cosmetic filters, reels, AI chatbots, how all of those design features are designed to keep your eyes on the platform. He'll test about the conclusions regarding the internally known safety risks. That is what was known to Meta about the safety risks of these design features, as well as how the age gating safeguards were ineffective. That is, the methods of seeing how old the users are were ineffective. And as I mentioned, Asa Raskin is the person that I kind of alluded to. He's the one that invented infinite scroll. What's interesting about him, his father was one of the original inventors with Steve Jobs of the Apple computer. So, how does this all work? It's critically important, before we go back to the roadmap of misrepresentations, to see what it is we're talking about. It's critically important to understand that the users on the platform, kids, teens, preteens, adults, the users on the platforms are not the customer. They are the product. The product of the platform is the behavior of the user that is captured. When you get Facebook or Instagram or WhatsApp or Messenger, you don't pay for it. You download it for free. How does a company make money if it's downloading apps for free? Well, it doesn't make the money with the user. It makes the money off of the advertising that it targets by learning what the user's behaviors are. So the product is the behavior of the users, the behavior of children, preteens, teens. That information is gathered by the algorithms and it's packaged. And in the end, that information is marketed to advertisers, and that is the chain of commerce. It's the advertising sold to those behaviors, to those data profiles. That is the commerce. Adam Mosseri, CEO of Instagram, will testify to that fact.
Instagram is an advertising business.
The primary way we make money is through advertising, so yes.
I'm not sure if everybody could hear that. The primary way we make money is advertising, yes. So we talk a lot about child safety, teen safety, whether or not it's a priority. You saw the first statement of Mr. Zuckerberg saying that it's not true that we put profit over safety. Well, let's talk about what the company did with respect to youth on their platform. You've heard people say in the evidence will be that Meta did not prioritize child safety, but this is where the unconscionable conduct we believe will come in. Instead of focusing and prioritizing youth safety on its platforms, Meta did something different. The evidence will be that Meta chose to prioritize trying to get teens and tweens on its platforms. The evidence will be in this case that Meta prioritized tweens over all other groups. And if you look at this chart, tweens is defined as between 10 and 12 years old. Instead of protecting as a priority, Meta, in its corporate culture, chose to prioritize and target teens. Teenagers remain the most engaged and valuable demographic, driving Meta's business objectives and revenue potential. Profit. Tweens, approximately age 10 to 12, are special. People who join Facebook as tweens have the highest long-term retention of all our age groups. We see that people who join Facebook as tweens have the highest long-term retention based on information we've gathered from 2007 to 2016. The evidence will be in this case that they not only failed to prioritize child safety, youth safety, teen safety, they wanted teens on their platforms. You'll see evidence in this case in 2023 confirming that. The reason we do all this teen residence work and improve user experience is ultimately so they spend more time and engage. And we have their eyeballs so we can make ad money off them. The evidence will be in this case, and this is the best evidence we can have, because one of the things that you will learn, one of the evidence will show, is that it's really hard, even today, for Meta to tell us how old people are on their platforms. So the best information we got from Meta on Instagram was in 2024. This is data from March of 2024, that here in New Mexico, approximately 200,000 users are teens, and approximately a little over 1 million people, adults, are on Instagram. If you add those two numbers up, you're talking about over half the population, almost 60% of the population of this state are on Instagram alone. So this is an issue. The evidence will be it's an issue for this state. And I'll make one other observation. The evidence will be that it's unknown how many of those adult users listed in this data provided to us by Meta are actually teens who misrepresented or lied about their age and getting on the platforms. So the teen number on a monthly average user basis could be more. You're going to hear from an expert in marketing. His name is Dr. Chandler. Dr. Chandler will tell you about this marketing, this targeting to teens. He's going to talk to you in the courtroom about the market for digital advertising provides a financial incentive for Meta to treat users, and particularly children, as sources of revenue. To point to where they're assigned, to the point where they're actually assigned an expected lifetime dollar value. Young users are assigned an expected lifetime dollar value within the company. He'll explain why in digital marketing, advertisers are increasingly willing to pay a premium for detailed information about the potential customers, the youth customers, and for the ability to show them advertising. This dynamic creates a massive financial opportunity for Meta, because gathering extensive information about teen users and selling the attention of those users to advertisers is what makes Meta money. You'll hear from Dr. Chandler about that targeting of youth. Finishing up on this concept of the basics of platforms, how they're used, how they're marketed, you hear testimony about the harms of social media. And the evidence will show that prolonged engagement on platforms for young users leads to a multitude of harms. Teens and tweens being in the areas of the internet that they're not equipped to mentally create or adds psychological problems. They become addicted. Depression can be exacerbated. Anxiety caused by comparing themselves to the perfect world. Sleeping disorders from nighttime use. Eating disorders, again, from trying to be thin to look perfect. The evidence in this case will be that they learn incorrectly that self-harm, like cutting themselves, can relieve stress and self-loathing. When children feel complete despair, they can even be encouraged to commit suicide. Prolonged engagement will also keep young users exposed more to bad actors in the virtual communities who prey on children and teens for sexual exploitation, as well as bullying. So let's go back to some statements. More misrepresentations of this company. The evidence will show that this company has made many iterations of this statement. We do not allow users under 13 on our platforms. This is an example of a statement that Mark Zuckerberg made before the U.S. Congress. Internally, however, after saying that to Congress under oath, what do we see? In the same year, 2018, internal documentation showing, looking at people we predict to be 13 and 14 today, we can estimate that there were 4 million people under the age of 13 in 2015 on Instagram alone. This represents 30% of the 10 to 12-year-olds in the United States. That internal information, the evidence will be wholly inconsistent with the public sworn statement, we do not allow users under 13 on our platforms. You will hear from, as we're told by the defendants, Antigone Davis. She was the head of, global head of safety at Meta. She said in 2018, the same year, we do very little to keep under 13s off our platform. The same year that Mr. Zuckerberg is saying that we don't allow it to Congress. 2019, our lack of proactive action detecting under 13 accounts undermines our credibility. In talking about age gating, it says it would be inappropriate for us to lean into the idea that we can take care of young users by checking their age. Is an example of another statement made by Meta about its platforms. This is by Mr. Merceri. Instagram is built for people 13 and older. If a child is under 13, the age of 13, they are not permitted on Instagram. Well, internally, 2020, an advisor to Nick Clegg, a former VP of Global Affairs, the evidence will be that he reported the fact that we say we don't allow under 13s on our platforms, yet have no way of enforcing it, is just indefensible. Ladies and gentlemen, the evidence will be, in this case, we believe that it's indefensible to say that we keep people under 13 off our platforms. And this is an acknowledgement internally in 2020 what that risk is. We know there are harms associated with preteen use of social media. This is that child safety presentation internally. I won't belabor it, but it does talk about for under 13 enforcement, there's no way to detect and remove at scale. At this moment in time in 2020, there are over 700,000 enforcement backlog cases of reported people, reported users under 13. They're saying that the models for ages are weak and not accurate, and the risk by having under 13s on the platforms on the bottom, inappropriate, harmful content experiences for minors. One last document on this topic. This is an internal saturation study of teens, where again in 2023, this is now 6 years after, we're not able to identify how many under 13 users are on our platform and thus being classified as teens. Let's move on to another area on this roadmap of exploitation, of sexual exploitation and self-harm. These are examples of statements that you'll hear during the course of this trial about sexual exploitation and self-harm and what Meta misrepresents about their protections with respect to those harms. Meta said in January of 2025 in its Instagram community standards, we have zero tolerance when it comes to sharing sexual content involving minors or threatening to post intimate images of others. Zero tolerance. Zero means zero. 2025. Yet, internally, the evidence will be that Meta had no ability to control the amount of sexual child exploitation images. That's what CEI stands for. They had no ability to control child exploitation images and the number of images that one could receive. In 2019, they wrote, we found users included on hundreds of NCMEC. NCMEC is the National Center for Missing and Exploited Children. And they said that they found hundreds of reports of users getting this type of material, and yet there was no enforcement or account review at Meta. You'll see in 2018 evidence that highly sexualized content was still a big problem in 2018, and importantly, that teens had a higher rate of exposure to violating content than non-teens, internally known to Meta, while making those public statements about teen users. In 2020, there's actually a report, the evidence will be, that they weren't even able to detect new sexually exploitive images, child exploitive images. The acronym there, IIC, is something a little different, but it's important because it's the next issue. IIC stands for inappropriate interactions with children. This is adults interacting with children inappropriately. And there, in this 2020 memo, the evidence will be that Meta was aware that its numbers for inappropriate interactions with children, notably on Instagram, were, quote, through the roof. In 2020, an internal report, the evidence will be said, we're not fulfilling our legal obligation to report child exploitation images or child exploitation solicitation to NCMEC. And then you'll hear from Mr. Behar about this study that he did in his second tour of Meta. Mr. Behar, again, is the person who went back twice. And he did a study when he went back the second time. This is the study I was referring to when his daughter was getting images and he wanted to understand how that was happening. He conducted something called the BEEF study. It's an acronym for Bad Experiences and Encounters Framework. And in looking at a period of 7 days, he received information from users of Meta that those surveyed, 16.3% of them were getting those types of images of nudity on their platform. Now, why that's important is because that data never saw the light of day. Instead, at the same time, Meta produced publicly something called CSER or CSER, depending on how you want to say it, but it's a CSER reports. And these were the public reports that Meta shared about what it was finding. Mr. Behar will tell you that this report, at the same time as BEEF, grossly understated the amount of nudity being seen on the platforms at that time. 0.02% versus 16%. So what, do we just have to rely on the information of Meta? Well, the Department of Justice here in the state of New Mexico also conducted some internal investigations. There was undercover investigations of what users were seeing on Meta's platforms. And these undercover investigators created undercover accounts, that is, accounts of people that didn't really exist, to try to see what kind of images were being shared, what kind of interactions were being produced. And you'll hear testimony from a witness by the name of Ricky Kitch about this. One of the accounts created is Isabi. This is a undercover account. It's obviously a young girl, and the interactions of Isabi between August and December of 2023 produced some horrifying interactions. I'm about to show a few images. These aren't all the images that Mr. Kitch found. These aren't all the images that you're likely to see during trial. And this is something we do very, very carefully because it is disturbing. But it's such an important story that it would be wrong to not show you. So the evidence in this case will be that this Isabi account generated contact. We've blocked out the imagery. That's our blockout of what kind of imagery was coming back to this undercover account. And on the right, you'll see an inappropriate interaction with a child. It's a written contact saying, "Hello, beautiful. I was glancing through profiles when I saw your profile. So pretty. I must confess, you have a nice smile. My interest has been piqued." I don't need to go into the whole statement. It goes on to ask for $5,000 a week. Would you be my honest baby? This undercover account generated this activity and this information. It also generated some photographs. This undercover account generated this type of imagery, again, that we have blocked out, but depicts the type of imagery that was being attracted to this particular fictitious account of a young user, a young female user. This information was provided to Meta. This account was shut down by Meta after the filing of the complaint in this case that produced some of these images. And so a new account was set up by the undercover investigator, and this account was called Daisy Rowanhorse. Again, for the purpose of trying to see what kind of activity was being generated, the New Mexico Department of Justice undercover investigation created this account. And before I continue about what this account generated, I'm going to stop and bring you to another statement of Meta. Meta said, to protect teens from unwanted contact, we restrict people over 19 years old from sending private messages to teens who don't follow them. That was a public statement on the Instagram post on March 17th of 2021. It suggests that Meta protects those under 19 from getting inappropriate contact from perpetrators, from people that have bad intent with respect to children. Well, that resulted in something that you'll hear about called Operation Metafile. The civil investigation morphed into a joint civil and criminal investigation, and 3 men, May of 2024, were arrested as a result of this undercover account. Fernando Clyde was arrested in May of 2024 for child solicitation by electronic communication and attempted criminal sexual penetration of a minor. I won't read it, but the dialogue back and forth between this perpetrator and this fictitious child is graphic. The next person arrested was Marlon Kellywood. Count 1, child solicitation by electronic communication device, attempted criminal sexual penetration of a minor. Again, the interactions between this fictitious, this undercover account and this perpetrator was documented, and it resulted in arrest on May of 2024. And the third person was arrested in April of 2024, again, for the same purpose, for child solicitation by electronic, and again, with details of the communication back and forth. And you'll hear about this investigation from Mr. Kitch. But what's really important, what's really interesting is the evidence in this case will be that when this was reported by the Department of Justice to Meta, it was learned through this case, through this process, through what's called discovery, that Meta actually, in going through their online profiles, had already seen other instances of their conduct. Clyde, Mr. Clyde, Meta knew, the evidence will be that Meta knew that Clyde had multiple instances of violations of adult nudity, sexual activity, bullying, and harassment from 2023 to 2024. And Meta did not report Clyde to NCMEC until his arrest as a result of Metafile. That is, none of the activity that preceded resulted in NCMEC being reported, or reportings going to NCMEC, until this investigation resulted in an arrest. Same is true for Mr. Reynolds. Meta, in this case, provided us answers saying that Meta knew Reynolds was a convicted sex offender, had instances of violent contact in 2021 and 2023, but the evidence will be that Meta did not report Mr. Reynolds to NCMEC until after his arrest as a result of the Metafile investigation. In fact, the evidence will be that Meta didn't disable his other active accounts until after this arrest. So how is this possible? Well, the evidence will be that the ability for Meta to track sex trafficking was severely under-resourced. In an internal document in Meta in 2020, it said that we have one engineer dedicated to this work. We have no data science to support or do basic understand work to the lower strikes. threshold for prostitution and sexual solicitation strikes, currently set at 17 times, which is too high. This area is severely undersourced. Ladies and gentlemen, the evidence is going to be that the way this under-resourced, inadequate system worked, at least as of 2020, was that it didn't take one strike for somebody like Mr. Reynolds. It didn't take two strikes for somebody like Mr. Reynolds or Mr. Clyde. It took 17 strikes for Meta's system to kick out that there was a problem. In another 2020 internal memo, there's a report that Instagram direct messaging had on a daily basis approximately 500,000 victims a day receiving inappropriate interactions with children. In 2023, there was data reported that on a single day, June 10th, 2023, it was observed that 2.7 million threads of communications, 9% of them, 238,000 of them, were between unconnected adults, that is, unknown adults with minors. The evidence will be that even Mr. Messeri internally recognized that Instagram in 2021 had become the leading two-sided market for human trafficking. Some of you may have heard of a classified online called Backpage that was shut down. And when that classified Backpage was shut down because of this type of conduct, Instagram, the evidence will be, became the leading market for trafficking. And then he goes on, we talked about end-to-end encryption. He said this problem is only going to get worse because we have end-to-end encryption on our messaging, which means if an unwanted adult brings a child into a conversation in a messaging app where that conversation cannot be traced, where that messaging disappears, the ability for law enforcement to do anything about it becomes incredibly difficult. Acknowledged here, the evidence will be by Mr. Messeri. So I'll try to go through these a little quicker, but in 2019, it was acknowledged internally. The evidence will be that Facebook allows pedophiles to find each other and kids. 2021, with respect to this end-to-end encryption for teens, context here is that there was a decision made to encrypt all private messages for under 13, and this has severe impact, as we know. So there was an acknowledgement that there was a decision to encrypt under 13 users with an acknowledgement of the hazards that would result. In 2020, the evidence will be that thousands of minors have been reporting this inappropriate interactions with children. This T1 abuse is the highest level of abuse. And even though we knew that there was this inappropriate interactions going on, more than 50% of which is sextortion, which can lead to suicide, we've done nothing. And in this internal memo in 2020, the conclusion was God only knows what happened to those kids. One other aspect relevant to this is something called private by default for teens. When setting up an account, there was a question about whether or not to make the messaging, the interactions between unknown adult users with teens, was to just set the accounts at default when setting up to be private, so you could not have that kind of interaction. And in this memorandum, the evidence will be in 2020 that that idea of trying to protect teens was explored private by default for teens, but the growth impact was too high. This is an example, and the evidence will be that this is an example of making a decision for profits over protection of teens by creating a default for teens and keeping unwanted interaction with adults. All right, and the last statement in this category is we remove any content that encourages suicide, self-injury, or eating disorders, including fictional content such as memes or illustrations, and any self-injury content which is graphic regardless of context. Remove content that contains instructions for extreme weight loss behavior. Facebook's Transparency Center. This is the type of statement that we believe the evidence will show is at very least misleading, if not untrue. This was in August of 2018. Internally, the evidence will be that one thing that's important for everyone to understand is that we cannot technically remove suicide and self-injury content from Instagram. So the next year, after saying that we remove it, internally, it was acknowledged that we cannot technically remove all SSI content from Instagram. In speaking about a news article that was going to be written in the Wall Street Journal, an advisor to Mr. Messeri said he, meaning the journalist, was writing a story that essentially argues that Instagram design is inherently bad for teenage girls. It leads to suicide and self-injury, poor mental health, dysmorphia. You'll hear that term. Dysmorphia is a negative body image leading to, in many instances, eating disorders. And it's not something we can fix with a product or an app or a design. And the arguments in the article saying that are based on our own research, so it's difficult to rebut. So you'll see here, ladies and gentlemen, that the evidence in this case will be that Instagram was aware that SSI, that suicide and self-injury content was dangerous to girls, and that this article was going to be written not based on some supposition of it, but by Meta's own internal data. And so some of the surveys on that show that, in fact, content for suicide and self-injury make teens feel worse and cause those types of harms. I'm going to briefly tell you about a witness that's going to come here. This is a historic case. This is a case that happened in the UK. It's a young girl named Molly Russell. She committed suicide. There were investigations about it. In the end, Molly Russell was exposed to this type of content. And by deposition, you'll hear the testimony of her father, a father who lost a daughter to suicide, a father who had to travel the experience of his daughter through the Instagram posts that he subsequently explored. These are some of those images, and these are some of the images that's found. The evidence will be to have been a contributing part, as he will tell you, to her taking her life. That was in 2018. Now, the last area on this roadmap of misrepresentations is whether or not Meta designed its applications, designed its platforms to addict people, to addict teen users. This is, again, Mark Zuckerberg. This is, again, him testifying under oath to Congress. And he said, and the way we design our algorithms is to encourage meaningful social interactions. So it's a common misconception that our teams, our goals, or even have goals of trying to increase the amount of time that people spend. But our goal is not. I don't give our newsfeed team or our Instagram team goals around increasing the amount of time that people spend. He's telling Congress that he doesn't set goals to his teams, including Instagram, to keep people on and spend more time on their platforms. This was asked in this litigation of Mr. Zuckerberg whether or not he made those representations.
So 3 times before Congress, you've testified under oath that you don't give your teams goals of increasing the amount of time people spend on your platforms, correct?
Yes.
All right. So he's not denying, the evidence will be he's not denying that statement. However, internally, the evidence will be that, in fact, they absolutely did. Our company position is that the time spent and engagement metrics proxy user value. We are not just tuning the algorithm to keep people scrolling as much and as long as possible, except mechanically, we absolutely do. Internally, Meta acknowledges this is now Adam Mosseri again, the head of Instagram. No one wakes up thinking they want to maximize the number of times they open Instagram that day. But that's exactly what our product teams are trying to do. And if you look to the left under the category, it is the strategy of Meta. You'll see other evidence, 2017, about goal setting and time spent. You'll hear in 2023 researchers saying things like, does Mel know that we literally optimize teen feeds for engagement? Another statement in this area of addiction is Antigone Davis, the head of global safety. Again, she's expected to testify here according to defendants in this case. She told Congress, I disagree with calling our products addictive. Well, there will be interactions that you see, emails, internal emails, where in fact it's acknowledged within the company among researchers that in fact Meta's platforms are addictive. Shaylee Roy's here is somebody that's very important. You'll see a moment. But the evidence will be that she called Instagram a drug, and in response a coworker wrote, laugh out loud, I mean all social media, we're basically pushers. In that same thread of communication, Shaylee goes on to say, seriously, it is. We're causing reward deficit disorder because people are binging on Instagram so much they can't feel reward anymore. Like their reward tolerance is so high. She later says, I know Adam Mosseri, the head of Instagram. I know Adam doesn't want to hear it. He freaked out when I talked about dopamine in my Teen Fundamentals lead review, but it's undeniable. It's biological and psychological. Here is that Teens Fundamental Review that she was talking about. This is the presentation that she made that the evidence suggests that you just saw that Adam freaked out about. Every time one of our teen users finds something unexpected, their brains deliver a dopamine hit. Teens are insatiable when it comes to feel-good dopamine effects. The evidence will be that, and this is the same continuation of that presentation, that Meta understood and appreciated in 2020 that teen brains are much more sensitive to dopamine. One of the reasons that the risk of drug addiction is higher for adolescents and keeps them scrolling and scrolling. And due to the immature brain, they have a much harder time stopping. You'll see more internal memoranda where they acknowledge the addictive nature. Relatively clear that younger people are less equipped to be able to handle the social media addictions. We don't yet understand how this might affect the development of their brains. There are other internal examples of acknowledging the addictive nature of these platforms. Like addicts, they feel like they're unable to stop. And the tools that we have are currently ineffective. And what's important about this presentation, Your Honor, I'm sorry, ladies and gentlemen, is that the evidence will show that this addictive nature of their platforms, they connect in their internal documentation to the design features that we talked about earlier, the design elements of the platforms, like the infinite scroll. If you look in the middle, autoplay, endless scroll, low-value notifications, things to get your eyeballs on the app. And you'll hear from a professor at Stanford University, an expert in the area of psychiatry and addiction, and she'll go through this and she'll explain how the world organizations deal with issues about excessive use, addiction, and the harms associated with being on these platforms for too long. So those are the reps. Those are the misrepresentations and the types of misrepresentations, and there'll be others, the types of misrepresentations that the state intends to present to you in evidence and demonstrate to you through evidence that are false and misleading knowingly. Let me just take a few minutes to tell you what this case is not about. We anticipate that the defendants will come up here and tell you that this isn't about Meta. That New Mexico has all of its own problems. It's got poverty, it's got poor education, it's got poor health. They will say that this is a problem of the state. They will say it's a problem for parents. You want to solve the problem, just shut the phone off. Just shut the computer down. They'll even say that it's a problem of schools. What they won't say is that they have a responsibility for this. And what's incredibly important, and the evidence will show, is that all of these aspects, all of these different forces, all of these different presences in children's lives have responsibility. And all of them are trying to do what they can. You'll actually hear from some witnesses in this case, like teachers and principals and police, who struggle every day to deal with the problems. And why is it so hard? Why is it so hard for parents and teachers to get around the problem? Remember that algorithm that we showed, that complicated formula behind the platform? How can parents and schools compete with that? This is acknowledged in internal documentation by Meta. This is an internal memo from 2020 that Meta has produced to us. And what's important about this memo is it doesn't say that the problem belongs to everybody else. It says populations are most at risk for developing mental health challenges when they are also more likely to have unhealthy social media use. These behaviors and challenges can develop into a feedback loop. So when you have on the left adolescents, youth, and teens, you have mental health challenges already in place, low socioeconomic status already in place. Those aren't other people's problems. Those are the types of populations, the evidence will be, by Meta's own acknowledgement, the types of populations that are the most at risk from being exposed to the social media harms. It's precisely the people, the youth in New Mexico, who deserve this protection, this safety-first mentality. And the evidence will be in this case that Meta doesn't do it. The last thing I'll say about bad parents and whether this is all about the parents is that internally, Meta actually looked at this issue. And there are two studies. I won't get into the technical part of studies, but there are two studies. One's called MIST, one's called Mercury. But you'll hear about studies internal to Meta that are not public. They don't make the light of day. But Meta internally looked at the issue of the role of the parent in dealing with social media harms. And the evidence will be in this case that it's Meta's own conclusion through its own studies that they never shared, that parents are not solely to blame. In fact, they're not to blame. Ladies and gentlemen, we anticipate that Meta will get up and tell you how much they put into safety, how many people they put responsible for child safety. The evidence in this case will be that if you quantify the value based on the information Meta has provided to us, if you quantify the value or the relative value, the relevant percentage of what that commitment is, it's only about 2.5% of what their revenue is. Meta's commitment to safety is not evident. In fact, its lack of commitment to safety first is unconscionable, it's willful, and it's something that is undeniable. I'll end by saying this. The United States Surgeon General, the Chief Medical Officer of the United States, issued an advisory in 2023. And in it, the Surgeon General said, we are in the middle of a national youth mental health crisis. And I am concerned that social media is an important driver of that crisis, one that we must urgently address. Ladies and gentlemen, the Attorney General of New Mexico brought this action to address this crisis, and we appreciate your time, and we appreciate the task that's before you to hold us to our burden, to listen to the evidence, only the evidence, not these openings, but the evidence that's presented after these openings are finished, apply the law at the end of the case that the judge is going to instruct, including the remedy, if any, that the judge will suggest that you have the right to decide upon and issue ultimately a verdict for the state of New Mexico for this case, for these violations of the Unfair Practices Act. On behalf of the state of New Mexico, the Attorney General, thank you so much for your time. Thank you, Your Honor.
Thank you, Counsel. All right, ladies and gentlemen, I want to thank you for your attentiveness. That was very evident throughout that opening. Given the timing of where we're at, what we will do is break for lunch. I'll ask you to please report back to the jury room by, say, 12:45. We're going to try and reconvene in here about 1 o'clock. And at that point, counsel for the defense will have their opening statement, and we'll take it from there. Okay? And while you're at lunch, please enjoy your lunch, but please be very mindful of the court's instructions about not talking to any other parties, not conducting any research, not looking at any coverage of this matter. Thank you very much for that, and I'll see you back here about 1 o'clock.
All right, for the drink.
All right, thank you all very much. Is there anything for us to address before we take a recess for lunch?
Your Honor, if I may have a few minutes. Alex Parkinson from Kellogg Hansen on behalf of Meta Platforms. A couple concerns. Your Honor, Meta has been raising now for months, weeks, and even today, the issue of 701 and lay witnesses who will be proffered as undisclosed experts. And I think that there has been a sense of the boy who cried wolf, but that came through today in the opening. Slide 16 of the state's opening showed 3 individuals, 2 disclosed experts, Dr. Naranya and Dr. McCoy. He was in the middle. And on the right side of Your Honor's screen was Mr. Raskin. Mr. Raskin was not disclosed as an expert. He is a fact witness. In fact, the Motley Rice law firm has tried the same thing in the JCCP, not disclosing Mr. Raskin, the same guy, as an expert, and the JCCP judge said, no, he's not going to come into the trial as an expert. And the reason I'm flagging this now is not just because it is a realization of the 701 concerns we have been articulating, but because Mr. Migliore told the jury, as a preface to slide 16, you'll hear about all of these features and their purpose by experts. Now the jury has it in their head that Mr. Raskin is an expert. We can quibble about whether that will be something they remember, perhaps not, perhaps it is a risk that he bears, but that is something that we have been raising consistently, and it is now in the jury's head. One other concern, if Your Honor will allow it. Sure. Slides 46 through 49 of the state's opening were about Operation Metafile. 2 concerns with that. That is a criminal investigation, and the very clear insinuation from counsel, I don't think it was even an insinuation, is that Meta bears some of the blame for not doing enough to go after those 3 criminal defendants who were indicted in a separate criminal action that the jury has now heard about. Concern number 1 is that the text messages that accompanied those 3 individual slides were not disclosed to Meta. That was graphic content that should have been disclosed per Your Honor's ruling. And if Mr. Migliore says, no, we only agreed to images, he is then telling Your Honor not to believe your lying eyes because this morning Your Honor saw a disclosure of text messages because language can be graphic as well. That was the message on the right of a slide that was handed up where there was personal identifying information that Your Honor said had to be redacted. Those images should have been disclosed to us over the weekend so that we could look at them and address them with Your Honor. Second concern, all of the statements about Meta being responsible for that did not open the door to raising the issues with ICAC and its lack of resources and its backlog of tips when it comes to criminal prosecutions, it took a battering ram and knocked that door all the way through. So the request is that we can now raise, in Mr. Huff's opening, the issue of the state's responsibility for resourcing criminal prosecutions relating to internet crimes against children, for the backlog of tips, because the door is wide open. And that was something that Your Honor said in the Mill rulings we could raise with you at the appropriate time.
We were just trying to figure out who was going to address that, Your Honor. I'm going to let Mr. Migliore address the statements regarding Mr. Raskin, although I think that is an issue that the court can handle when Mr. Raskin comes to testify.
I will just tell you, I don't know how other judges address the issue of who will be an expert before that expert is proffered, but this court makes that determination based on what is requested by way of expert scope and deals with it at the time. So we'll see how that turns out.
Exactly. With respect to Metafile, Your Honor, the slides that Mr. Migliore showed were publicly available. Frankly, I think they're referenced in Meta cyber tips that were reported to NCMEC after Operation Metafile. The slides have been used, I believe, as exhibits in depositions. Those aren't graphic images. They are nothing that the court would have required leave of court. It is publicly available information. I don't think anything about Mr. Migliore's presentation opened the door to what defendants want to argue. This case is and remains about what Meta said and did. And part of what Meta said and did came to light in Operation Metafile. That doesn't mean that that Meta can now try to get into all kinds of other investigations and resources and other type and distract the jury with the sideshow about how the state has resourced ICAC and what ICAC does with respect to tips that have nothing to do with Meta or anything else. And so we disagree that there has been any door opening, let alone a battering ram, which I think is a little bit of hyperbole.
Well, I just want to reserve on the slide issue. With respect to Raskin, I understand the court's position and appreciate it. With respect to whether or not we disclosed, what I represented to the court when asked about what I could disclose on the Saturday before opening, I said that I would, because of their repeated concern about photographs, that I would voluntarily disclose pictures. And so the pictures of children, because of their concerns as were expressed early this morning about the safety of minors. This is not anywhere near what I suggested or that the court even discussed, producing images of the messaging that was in an exhibit that's on our exhibit list.
Your Honor, if I may.
All right. What, briefly?
The fact that the images were public is not dispositive here because the images they did disclose, some were public because they were in the complaint, specifically complaint images 35 and 36, which was the image of the woman in the park. They showed that to Your Honor this morning from the complaints. That's not the dispositive factor here. But more important, on the opening door thing, around slide transcript page 113 and 114, here's some of the phrases that were used in the opening by the state. Under-resourced, backlog. The claim was made, they will say this is a problem of the state. The door has absolutely been opened. They've actually anticipated that we would be the ones to open it and pre-butted it. So we have to be able to say, you know, you heard counsel from the other side say this is a problem of the state, that Meta's under-resourced, that Meta has a backlog. Well, there are two sides to both stories. The door's been opened.
All right. Thank you, counsel. So let me say, it might be helpful that we're having this discussion now, because I absolutely disagree with plaintiffs that this court was in any way ambiguous about what needed to be disclosed. It was if you were going to use a reference an exhibit in the opening slides, you know, I did say you didn't have to provide the roadmap type demonstrative exhibits, but I agree with the defense that not disclosing text messages that you are graphically including in the slides is contrary to this court's order. So if you all think that we are going to go through 7 weeks with you all trying to parse your way around, I think this court's clear orders, things will not go well. So I absolutely agree that the defense has a valid point about the text messages. And going forward, rather than trying to find ways to play mental gymnastics to get around the clear meaning of what the court says, how about either raise it in advance or abide by what the court said? That, I think, will keep us in much better state going forward. On the ICAC issues, let me ask you, Mr. Parkinson, I guess what I don't know is what range of issues, let me just hopefully not be irritatingly opaque, and that is, I don't believe that the door is necessarily battered or open to the extent that we're going to have a mini trial now on how the state runs its general law enforcement operations, other unrelated investigations. But are you planning on discussing the sort of specific law enforcement issues related to what's at issue here? Online, tips at online enforcement, and that sort of thing.
Your Honor, if I may, and I will not be opaque, and I'll preview the opening. With Your Honor's permission, and we will not do this without Your Honor's permission, which is why I raised it, we would like to bring out 2 points that were overwhelmingly clear from the discovery that Meta took and, frankly, that the state offered in this case. Number one, the Attorney General's office in the state has made a conscious decision to under-resource its Internet Crimes Against Children unit in favor of other departmental priorities or otherwise. Number two, as a consequence of that, there is a backlog of tips relating to internet crimes against children that the Attorney General's office is sitting on top of. And given the statements that were made about Meta being under-resourced, Meta having a backlog, and Meta saying this is going to be all a problem of the state, which isn't fair, I think that that's very goose gander.
All right. So I would say, with respect to sort of governmental or other priorities, I don't believe the door is open to that. That is something inherent to, I think, every government having to make some priority decisions with limited resources. With respect to the existence of a backlog or the like, I think given what was presented in the opening by the plaintiffs, that is a reasonable realm for your statement.
May I respond? Your Honor, may I respond briefly?
Mr. Ackerman, so if you want to briefly, yes.
I will be very brief. The discussion of Metafile occurred in the context of Meta's statements. Any Meta's statements regarding safety on its platforms and regarding the ability of adults to connect to minors. Any discussion of a Nick